Court calls the case, People versus Jason Williams.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Williams. Mr. Williams, please state your name for the record.
Jason Williams.
Your Honor, we're here for a pre-trial. There's also a pending bond violation.
There is.
I have spoken about the violation with my client. I believe today he's going to admit to the violation, and he would like to make a statement on his own behalf.
Yeah, so that being said is I admit to the violation, and I know I wasn't supposed to have alcohol in my system. No excuse, but the last few weeks, sir, I had so much going on in my life, money issues, the car issues, whatnot, family issues, and no, there's no excuse because you said what you said, and I wasn't trying to get in trouble or anything, and I've still been going to my program, and that's still been helping me myself, going to my program weekly by weekly and dropping with them and whatnot, and just still trying to grow as an individual and whatnot. So that's all I have to really say right now, sir.
If I may, Your Honor, add to that. So Mr. Williams is attending substance abuse treatment in Detroit. I believe it's called Community Care First.
Yes.
He goes there weekly for group therapy and is also attending AA meetings.
Do I have any documentation regarding any of that?
I believe I have provided to Ms. Londi. I'm happy to give it to the court. He gave me his schedule and
but how do I know that he's actually going to that?
Is that what?
I have his enrollment paperwork. I'm happy to get an updated progress report from that program and get that to the court.
And we sign in every week. So
we
sign in every week. And I think you said that's part also. Talk down.
How long has he been doing that?
I've been doing this going on 3 months. Oh, well, it's January, 20th, February, March. Almost going on 3 months.
Nothing, well, I was going to say nothing, but I did want the court to know he is fully employed at U-Haul. He works full-time there. He is hoping to stay out of custody and continue working, continue going to his treatment program, and just, get things back under control.
Yes.
I'm sorry, what is that?
Oh,
Ms. Londi.
In anticipation of the court accepting the admission to the bond violation, people would request enough change in bond conditions. First and foremost, there was a prior bond violation in March that the court accepted the admission to would allow the defendant to continue testing with where he's testing now. Unfortunately, this is an OWI case, and it does have a prior from 2012, and now this is the second time that we've got an alcohol violation. So I am requesting that he be placed on a scram tether. I do believe that community safety and the public safety risk of having this person not be on 24-hour testing supervision is too great to ignore at this time. So I am requesting the court order that and have him placed on the scram tether.
My problem is that and this is why I don't like to do it this way. I gave you a chance, Mr. Allen. I gave you a chance with the last violation.
What? Just for me to speak, I wasn't informed that about so I didn't know anything about the last violation. Like this would have all been like this wouldn't even happen again. It wouldn't never happen again. Like it wouldn't never happen again. Like I say, I'm still just I'm working on it, sir. I definitely apologize. I'm just hoping like you could please work with me just one more chance, and you won't hear about it.
Here's the thing. I don't mind giving people chances, but I gave you an opportunity to test in Novi with results to community correction. I did that back, I think it looks like on March 5th. And I get these negative tests. Well, first of all, there were like numerous missed samples.
No, oh, sorry.
I'm going by their report.
Okay.
Then I get negative results. Then on March 27th, I get, well, that's when the ETG comes through. I get a positive alcohol result. Here's part of my problem. I don't know how much you're drinking. And so that comes through, you know you've been drinking. And then on the 2nd, we get a negative result from your ETG.
Right.
Then by the 9th, you're drinking again.
And the 2nd. And that's like,
What?
I'm just up here thinking, sir, like 2nd, like 9th should have been, came back negative also.
It came back negative.
Yeah, negative on the 2nd.
On the 2nd, it's negative because
Right.
it's only going to pick it up for whatever period in time. But then by the 9th, you're drinking again. Or sometime shortly before that or before that, you're drinking again. And I don't have any reason to doubt anything, but I don't know what treatment you're in. I don't have that in front of me, first of all, right now. I understand why I may not. But also, I don't even understand or nor can I trust what you're indicating is your participation with it.
So, like at the meetings, sir, there are 2-hour meetings every week. Like they're NAA, talk to a counselor and whatnot. And like once again.
Did you tell the counselor you're drinking?
You said, well, did I tell the counselor I'm drinking? No, I'm not drinking.
Pardon?
I'm not drinking. Like I'm confused right now. You said that.
Pardon?
Did you tell your counselor that you had the positive alcohol test?
No, because
didn't.
I just got informed. On Monday, so I was going to tell them this.
Well, hold it. Whether you got informed or not, you knew you were drinking.
No, I just got informed on Monday that I violated. That's what I'm telling you on Monday.
Okay, listen real close to what I'm saying. Whether you were violated or not, right?
Right.
You knew you were drinking. And so my question is, you knowing that, did you tell your counselor you were drinking?
No, I haven't spoke with her yet. I was going to speak with her on Friday about that and tell her like.
I thought you went every week.
I go every week.
Okay.
Every week.
So today is the 23rd, right?
Right.
No, just listen to me.
Okay.
Today's the 23rd, which means presumably from the time of the results, you had at least 2 of those meetings. And you haven't told your counselor that you were drinking. That's from the last incident.
All right. Last week, sir, we was off due to Easter on Friday. So
Here's the problem, young man. You're going to have to get your addiction under control. You got an excuse for everything. If you didn't get caught, you would say nothing, either to your treatment, certainly not to the court, it seems to me. And then you would go about continuing to drink. I'll adjourn the matter to May 21st, 2025, 9 a.m. At this point, given his violation, his admission to the violation, defendant's bond is hereby ordered revoked. I will reconsider giving him a bond and maybe releasing him with certain conditions once I see the information or progress report.
I was going to ask, Your Honor, do you think that we could get him assessed by the jail and see if there's any treatment programs that this county can offer him maybe a higher level of treatment than he's already engaged in.
Well, I don't know what he's engaged in. I mean, I can't, because what he's telling me doesn't make a whole lot of sense.
Well, I'll get that to the court and whatever other information I can obtain.
All right. Thank you. Court does call.
This courtroom hearing begins as a routine pretrial conference, but it quickly transforms into a tense and emotionally charged moment when Jason Williams admits to violating his bond conditions. Standing before the court, Williams acknowledges that alcohol was found in his system, something he was explicitly prohibited from doing. He doesn't deny responsibility. Instead, he attempts to explain himself, citing overwhelming personal struggles, including financial stress, car problems, and family pressure. His tone is apologetic, almost pleading, as he insists that he never intended to get into trouble and claims he is genuinely trying to improve his life. Williams tells the judge that he has been attending a substance abuse treatment program and participating in regular group therapy and AA meetings. He describes these programs as helpful and says he is actively trying to grow as an individual. His defense attorney reinforces this narrative, emphasizing that Williams has been attending treatment for nearly 3 months and is fully employed at U-Haul, working full-time. The defense asks the court to consider allowing him to remain out of custody so he can continue working and pursuing treatment. However, the judge is not convinced. Calm but firm, the judge presses for documentation and accountability. While enrollment paperwork is mentioned, the court expresses serious concern about trust. The judge explains that this is not Williams' first violation. In fact, there was a prior bond violation earlier in the year, and the court had already shown leniency by allowing continued testing rather than immediate custody. Despite that chance, another alcohol violation has occurred, this time in a case involving a prior conviction. The prosecution steps in and requests stricter bond conditions, arguing that public safety is at risk. Given the repeated alcohol violations, they ask for 24-hour alcohol monitoring through ASC RM tether. The judge's frustration becomes more apparent at this point. Addressing Williams directly, the judge explains that chances were already given and ignored. As the judge reviews the testing timeline, inconsistencies begin to surface. There are missed samples, alternating negative and positive test results, and repeated alcohol use shortly after clean tests. The judge points out the troubling pattern. Williams drinks, tests negative when alcohol is no longer detectable, then drinks again. This cycle raises serious doubts about his honesty and commitment to recovery. The most damaging moment comes when Williams admits that he did not inform his counselor about drinking even though he knew he was consuming alcohol. The judge makes it clear that whether or not Williams had been officially notified of the violation is irrelevant. What matters is that he knew he was drinking and failed to disclose it to his treatment providers. That omission severely undermines his credibility. At this point, the judge delivers a blunt assessment. Williams has an excuse for everything but no accountability. The court cannot trust his statements, his treatment claims, or his commitment to sobriety. The judge explains that if Williams hadn't been caught, he likely would have continued drinking without telling anyone, neither his counselor nor the court. The decision is swift and serious. The judge revokes Williams' bond, ordering him into custody. While the court leaves open the possibility of reconsidering release in the future, it makes clear that any such decision would require verified treatment progress reports and concrete evidence, not promises. The hearing concludes with a sobering message. Addiction must be addressed honestly, and second chances mean nothing without responsibility. In the courtroom, sympathy has limits and credibility is everything. If you found this courtroom moment intense and eye-opening, make sure to like the video, subscribe for real courtroom stories, and comment below with your thoughts. Should the judge have given him one more chance, or was jail the right call? Turn on notifications so you never miss another powerful courtroom breakdown.